A warm good morning to all. Welcome to the first session of Impact Lecture Series organized by Institutions Innovation Council of St. Thomas College, Palai, sponsored by Ministry of Education's Innovation Cell and AICT. These Impact Lecture sessions intend to generate awareness and skill of innovation, entrepreneurship, startups, and IPR among students and faculties of IIC. Institutions Innovation Council established that higher education institutions helps in planning, channelizing, and organizing round-the-year activities in the areas of innovation, entrepreneurship, and IPR to sensitize and motivate students and faculties to pursue innovation and startup during their academic. Conduct of impact lecture sessions in higher education institutions are one of the approaches under the IIC program to support IIC institutions to generate awareness on innovation, IPR, and startup in such institutions with funding assistance from Ministry of Education's Innovation Cell and AICTE. The impact lecture sessions in selected IIC institutions will not only streamline campus innovation and startup ecosystem, but also help in establishing strong connection with ecosystem enablers at regional and national level, and aware students and faculty members about innovation ecosystem in their surrounding and at national level. The Impact Lecture Series scheme requires IIC institutions to organize at least 2 sessions in the field of innovation, IPR, and startup by inviting successful innovators, patent experts, and entrepreneurs and resource persons from innovation and startup ecosystem. This online Impact Lecture Series, organized by IIC of St. Thomas College, Palai, consists of 2 sessions. Each session contains 2 lectures of probably 1.5 hours duration. And the themes and lecture topic of these sessions are related to innovation, startups, IPR, etc. as mentioned earlier. I hope this session will be productive and useful for every participant. Morning session of today's lecture will be handled by Ms. Devika R. Nair, Examiner of Patents and Designs, Patent Office, Chennai. Ma'am, I feel privileged to extend my welcome to you for this lecture series on behalf of IIC of St. Thomas College. Next, I would like to welcome our dear Vice Principal of St. Thomas College, Palai, Mr. Jogi Alexa, Ms. Tinju P. James, Assistant Professor of Department of Political Science, Ms. Elsa George, Assistant Professor of Department of Physical Education, IIC officials of St. Thomas College, all other teachers and dear participants to this program. Online Impact Lecture Series conducted by IIC of St. Thomas College, Palai. He is new to this position, but he is well known to St. Thomas College. Here, I wholeheartedly invite our Honorable Vice Principal, Mr. Jogi Alexa, for the Presidential Address. Sir, please.
St. Thomas കോളേജിലെ IIC-യുടെ നേതൃത്വം കൊടുക്കുന്ന അധ്യാപക സുഹൃത്തുക്കളെ, ഇന്ന് ഈ IIC-യുടെ ഇമ്പാക്ട് ലെക്ചർ സീരീസിൽ ആദ്യ സെഷൻ കൈകാര്യം ചെയ്യുന്ന മിസ് ദേവിക ആർ നായർ, ഈ പ്രോഗ്രാമിൽ പങ്കെടുക്കുന്ന അധ്യാപകരെ, വിദ്യാർത്ഥികളെ, സുഹൃത്തുക്കളെ, വളരെയേറെ പ്രതീക്ഷയോടുകൂടിയാണ് കേന്ദ്ര സർക്കാരും സംസ്ഥാന സർക്കാരും ഇത്തരത്തിലുള്ള ഒരു ഉദ്യമത്തിന് തുടക്കം കുറിച്ചിരിക്കുന്നത്. നമുക്കറിയാം, നമ്മുടെ രാജ്യം ഇന്ന് നേരിടുന്ന ഏറ്റവും വലിയ വെല്ലുവിളി എന്ന് പറയുന്നത് തൊഴിലില്ലായ്മയാണ്. പ്രത്യേകിച്ചും കോവിഡ് മഹാമാരിക്ക് ശേഷം നമ്മുടെ രാജ്യത്തെ തൊഴിലില്ലായ്മയുടെ കണക്കെടുക്കുകയാണെങ്കിൽ 2019 അപേക്ഷിച്ച് 2022 ആയപ്പോഴേക്കും അതിൻ്റെ ഇരട്ടിയിലധികമായി തൊഴിലില്ലായ്മ വർദ്ധിച്ചു വരുന്ന ഒരു സാഹചര്യമാണ്. ഒരുപക്ഷെ നമ്മുടെ നാട്ടിലെ യുവാക്കൾക്കും യുവതികൾക്കുമെല്ലാം തൊഴിൽ കൊടുക്കുക എന്നുള്ളത് സർക്കാരിന് മുന്നിൽ ഒരു വലിയ വെല്ലുവിളിയായി മാറുകയാണ്. തന്നെയുമല്ല, നമുക്കറിയാം, നമ്മുടെ പൊതുമേഖലാ സ്ഥാപനങ്ങൾ പലതും പുത്തൻ നവലിബറൽ നയങ്ങളുടെ ഭാഗമായിട്ട് അതെല്ലാം സ്വകാര്യവൽക്കരിക്കപ്പെടുകയും കൂടുതൽ ടെക്നോളജി അധിഷ്ഠിതമായ വ്യവസായങ്ങൾ വരികയും ചെയ്തതോടുകൂടി തൊഴിലില്ലായ്മ അല്ലെങ്കിൽ കൂടുതൽ ആളുകളെ ആവശ്യമില്ലാത്ത രീതിയിലേക്ക് കാര്യങ്ങൾ പോയിക്കൊണ്ടിരിക്കുകയാണ്. ടെക്നോളജി വികസിക്കുന്നതോടുകൂടി എല്ലാം ഒരുപക്ഷെ കമ്പ്യൂട്ടറൈസ്ഡ് ആകുമ്പോൾ, അല്ലെങ്കിൽ ഡ്രൈവർമാരില്ലാതെ പ്ലെയിൻ ഓടിക്കാം എന്നൊക്കെ നമ്മൾ ദിവസങ്ങളിൽ പത്രങ്ങളിലൊക്കെ വായിക്കുന്നുണ്ട്, നമ്മൾ കാണുന്നുമുണ്ട്. ഈ സാഹചര്യത്തിൽ നമ്മൾ ഉന്നത വിദ്യാഭ്യാസ രംഗത്ത് ഏർപ്പെട്ടിരിക്കുന്ന എങ്ങനെ നമുക്ക് വിദ്യാർത്ഥികൾക്കും അധ്യാപകർക്കും സ്വയം സംരംഭകത്വം വളർത്തിയെടുത്തുകൊണ്ട് തൻ്റെ സ്കിൽ ഉപയോഗിച്ചുകൊണ്ടും തൻ്റെ ബുദ്ധി ഉപയോഗിച്ചുകൊണ്ടും തങ്ങൾ നേടിയെടുത്തിട്ടുള്ള അറിവ് ഉപയോഗിച്ചുകൊണ്ടും പുതിയ സംരംഭകത്തിലേക്ക് മാറാം. അതിലൂടെ നമുക്ക് മാത്രമല്ല നമ്മുടെ ചുറ്റുമുള്ള ആളുകൾക്കും തൊഴിൽ കൊടുക്കുവാൻ സാധിക്കുന്ന സാഹചര്യം, അത് ചെറുതായിക്കൊള്ളട്ടെ വലുതായിക്കൊള്ളട്ടെ, പുതിയ വ്യവസായങ്ങളായിക്കൊള്ളട്ടെ ചെറുകിട വ്യവസായങ്ങളായിക്കൊള്ളട്ടെ, അത് തുടങ്ങുവാനുള്ള ഒരു പ്രോത്സാഹനവും അതിനുള്ള പരിശീലനവും നൽകുക എന്നുള്ളതാണ് ഈ ഇൻസ്റ്റിറ്റ്യൂഷണൽ ഇന്നൊവേഷൻ പ്രോഗ്രാം കൊണ്ട് ഉദ്ദേശിക്കുന്നത്. കേന്ദ്ര സർക്കാരിൻ്റെ കീഴിലുള്ള മിനിസ്ട്രി ഓഫ് എഡ്യൂക്കേഷൻ, നേരത്തെ അത് മാനവ വിഭവശേഷി വികസന വകുപ്പായിരുന്നു, അത് പിന്നീട് എഡ്യൂക്കേഷൻ ഡിപ്പാർട്ട്മെൻറ്റായി മാറി. അത്തരത്തിൽ കേന്ദ്ര വിദ്യാഭ്യാസ വകുപ്പിൻ്റെയും IICTയുടെയും ആഭിമുഖ്യത്തിൽ ഇത്തരത്തിലുള്ള സംരംഭക പരിപാടികൾക്ക്, അത് കുട്ടികളിലേക്ക് അത് ആകർഷകമാക്കുന്ന രീതിയിൽ ഉള്ള പ്രോഗ്രാമുകൾക്ക് വേണ്ടി വളരെയേറെ തുക ബഡ്ജറ്റിൽ മാറ്റിവെച്ചിരിക്കുകയാണ്. വളരെ ചെറിയ സംസ്ഥാനമായ കേരളത്തിൻ്റെ കഴിഞ്ഞ വർഷത്തെ പൊതു ബഡ്ജറ്റ് നമ്മൾ പരിശോധിക്കുകയാണെങ്കിലും നമുക്കറിയാം, ഇത്തരത്തിൽ ട്രാൻസ്ലേഷണൽ റിസർച്ച് സർവകലാശാലയുടെ ബഡ്ജറ്റിൽ വളരെ ഭീമമായ തുകയാണ് അതിന് മാറ്റിവെച്ചിരിക്കുന്നത്. നമ്മുടെ റിസർച്ച് ലാബുകളിലൊക്കെ നിരവധിയായ ഗവേഷണങ്ങൾ നടക്കുന്നുണ്ട്. ആ ഗവേഷണങ്ങൾ നടക്കുമ്പോൾ ആ ഗവേഷണത്തിൻ്റെ ഫലങ്ങൾ ജനങ്ങളിലേക്ക് എത്തുന്നുണ്ടോ? വെറുതെ എന്തെങ്കിലും കുറച്ച് കാര്യങ്ങൾ ചെയ്ത് ഒരു ഡിഗ്രിയും വാങ്ങി പോകുവാൻ, തൻ്റെ ജോലിയുടെ ഒരു പ്രൊമോഷന് വേണ്ടിയോ എന്തെങ്കിലും ഇൻക്രിമെന്റ് നേടുന്നതിനോ വേണ്ടി മാത്രമായിട്ടാണോ ഈ ഗവേഷണം ചെയ്യുന്നത്? അങ്ങനെയുള്ള ഗവേഷണങ്ങളെ ഇനി പ്രോത്സാഹിപ്പിക്കേണ്ടതില്ല. ഇത് പൊതുസമൂഹത്തിന്, കാരണം നമ്മൾ മുടക്കുന്ന ഓരോ തുകയും നമ്മളുടെ നാട്ടിലെ ജനങ്ങളുടെ നികുതിയിൽ നിന്നും നമ്മൾ ഈടാക്കുന്നതാണ്. തീർച്ചയായിട്ടും നമ്മുടെ ഉത്തരവാദിത്വം സമൂഹത്തോടാണ് എന്ന ബോധ്യം ഉൾക്കൊണ്ടുകൊണ്ട് തന്നെ ഈ ഗവേഷണങ്ങളെ പ്രോത്സാഹിപ്പിക്കുകയും ആ ഗവേഷണങ്ങളുടെ ഫലങ്ങളെ ജനങ്ങളിലേക്ക് എത്തിക്കുവാൻ, അത് കൃഷി ആയിക്കൊള്ളട്ടെ, വ്യവസായമായിക്കൊള്ളട്ടെ, ടൂറിസം ആയിക്കൊള്ളട്ടെ, അതുമായി എന്ത് രീതിയിലുള്ള പദ്ധതികളുമായിക്കൊള്ളട്ടെ, അത്തരത്തിൽ ആ ഗവേഷണങ്ങളെ മുഴുവൻ ജനങ്ങളിലേക്ക് എത്തിക്കുന്ന, അതല്ലെങ്കിൽ അത് പുതിയ സംരംഭങ്ങളായി മാറുന്ന പദ്ധതിക്ക് ട്രാൻസ്ലേഷണൽ റിസർച്ച് എന്ന പദ്ധതി തന്നെ സർക്കാർ ആവിഷ്കരിച്ച് നടപ്പാക്കി വരികയാണ്. പുതിയ ഗവേഷണ സ്ഥാപനങ്ങൾ ആരംഭിക്കുന്നതിന് വേണ്ടി കേന്ദ്ര ഗവൺമെന്റും സംസ്ഥാന സർക്കാരും വളരെയേറെ തുക മുതൽ മുടക്കുന്നുണ്ട്. പക്ഷേ അതിൻ്റെതായ ഗുണം നമ്മൾ കൈവരിക്കുന്നുണ്ടോ എന്ന് നമ്മൾ ഒന്നുകൂടി ചിന്തിക്കേണ്ടതായിട്ടുണ്ട്. അപ്പോൾ പഠനത്തിൽ ഏർപ്പെട്ടുകൊണ്ടിരിക്കുന്ന നിങ്ങൾക്ക് തന്നെ നിങ്ങളുടെ പഠനത്തോടൊപ്പം ഏൺ വൈൽ യു ലേൺ എന്നൊക്കെ നമ്മൾ പറയുന്നത് പോലെ തന്നെ നമുക്കറിയാം, വിദേശ രാജ്യങ്ങളിലൊക്കെ കുട്ടികൾ ഉച്ചവരെ പഠിക്കുന്നതോടൊപ്പം ഉച്ച തിരിഞ്ഞ് അവർ പാർട്ട് ടൈം ജോലിയിലേക്കാണ് പോകുന്നത്. അത്തരത്തിൽ നിങ്ങൾ ജോലിയിലേക്ക് പോകണമെന്നല്ല ഞാൻ പറയുന്നത്. നിങ്ങൾ പഠിച്ചുകൊണ്ടിരിക്കുന്ന വിഷയവുമായി ബന്ധപ്പെട്ടുകൊണ്ട് തന്നെ നിങ്ങൾക്ക് പാഠപുസ്തകത്തിലൂടെയും ലൈബ്രറിയിലൂടെയും ലബോറട്ടറിയിലൂടെയും നിങ്ങൾക്ക് ലഭിക്കുന്ന അറിവുകൾ, ആ അറിവിനെ നമുക്കൊരു സംരംഭകത്വമാക്കി മാറ്റിയെടുത്തുകൊണ്ട് പുത്തൻ കാഴ്ചപ്പാടിലൂടെ ജനങ്ങളെ അതിലേക്ക് ആകർഷിക്കുവാൻ സാധിച്ചാൽ, പുതിയ പ്രോഡക്റ്റുകൾ ഉൽപ്പാദിപ്പിക്കുവാൻ സാധിച്ചാൽ, അതിലൂടെ നമുക്ക് തീർച്ചയായിട്ടും നമ്മുടെ രാജ്യത്തിന് വലിയ ഒരു കോൺട്രിബ്യൂഷൻ ആയിരിക്കും നിങ്ങൾക്ക് നൽകുവാൻ സാധിക്കുക എന്ന കാര്യത്തിൽ യാതൊരു തർക്കവും വേണ്ട. അതിനെ പ്രോത്സാഹിപ്പിക്കാൻ വേണ്ടിയാണ് ഇത്തരത്തിലുള്ള ഇന്നൊവേഷൻ കൗൺസിലുകൾ നമ്മുടെ കലാലയങ്ങളിൽ പ്രവർത്തിച്ചു കൊണ്ടിരിക്കുന്നത്. തീർച്ചയായിട്ടും ഇതിന് നേതൃത്വം കൊടുക്കുന്ന അധ്യാപകരെ ഞാൻ ഈ അവസരത്തിൽ അഭിനന്ദിക്കുകയാണ്. കൊമേഴ്സ് വിദ്യാർത്ഥികൾക്ക് അവർ പഠിച്ചുകൊണ്ടിരിക്കുന്ന മേഖലയുമായി ബന്ധപ്പെട്ട്, പ്രത്യേകിച്ച് ബാങ്കിങ് മേഖല, അതുപോലെ തന്നെ കോർപ്പറേറ്റ് മേഖല, ഇതൊക്കെയായിട്ട് ബന്ധപ്പെട്ട് ധാരാളം കാര്യങ്ങൾ ചെയ്യുവാൻ സാധിക്കും. അതുപോലെ തന്നെ സുവോളജി, ബോട്ടണി, കാർഷിക മേഖലയുമായിട്ടും ഒക്കെ ബന്ധപ്പെട്ട് വളരെയേറെ കാര്യങ്ങൾ ചെയ്യാൻ സാധിക്കും. ഫിസിക്സ് ഡിപ്പാർട്ട്മെന്റുകൾക്ക് വ്യാവസായികമായിട്ടുള്ള ഉൽപ്പന്നങ്ങൾ, നിരവധി കോളേജുകൾ ഇപ്പോൾ തന്നെ ഇത്തരത്തിലുള്ള പ്രവർത്തനങ്ങൾ ആരംഭിച്ചു കഴിഞ്ഞിട്ടുണ്ട്. അതാണ് നമ്മൾ മനസ്സിലാക്കേണ്ടത്. അപ്പോൾ നമ്മുടെ രാജ്യവും നമ്മുടെ സംസ്ഥാനവും ഇന്ന് നേരിടുന്ന ഏറ്റവും വലിയ വെല്ലുവിളി ഊർജ രംഗത്തുണ്ടാകുന്ന വെല്ലുവിളികൾ, അതുപോലെ തന്നെ ആരോഗ്യ രംഗത്ത് ഒരുപക്ഷെ നമ്മുടെ സംസ്ഥാനം കുറേയൊക്കെ മുന്നോട്ട് പോയിട്ടുണ്ടെങ്കിൽ പോലും നമുക്കറിയാം, ഓരോ വർഷവും പുതിയ പുതിയ അസുഖങ്ങൾ, അത് നിപ്പയോ അതല്ലെങ്കിൽ ഈ പറഞ്ഞ കോവിഡോ മാത്രമല്ല, ഇനി വരും കാലങ്ങളിൽ പുതിയ രീതിയിലുള്ള കാര്യങ്ങൾ വരുമ്പോൾ അതിനെയൊക്കെ പ്രതിരോധിക്കാൻ സാധിക്കുന്ന രീതിയിലുള്ള സംരംഭകത്വം, അത് മെഡിസിൻ മാത്രമല്ല ഞാൻ ഉദ്ദേശിക്കുന്നത്, അവരെ പുനരധിവസിക്കുന്ന കാര്യത്തിലും അവർക്ക് മറ്റ് മേഖലകളിലേക്ക് കോവിഡ് മൂലം നമുക്കറിയാം നമ്മുടെ വീടുകളും ഓഫീസുകളും അടഞ്ഞു കിടന്നപ്പോൾ പലരും തൻ്റെതായ പ്രവർത്തനങ്ങളിൽ ഏർപ്പെട്ടുകൊണ്ട് തന്നെ തൻ്റെ ജീവിതം മുന്നോട്ട് കൊണ്ടുപോകാൻ സാധിച്ചു. പക്ഷേ ഇത്തരത്തിലൊന്നും കാര്യങ്ങൾ ചെയ്യാതിരുന്ന ആളുകൾ ഒരുപക്ഷെ മാനസികമായി വലിയ ബുദ്ധിമുട്ടിലേക്ക് നീങ്ങുകയും ചിലരെങ്കിലുമൊക്കെ ആത്മഹത്യ പോലും ചെയ്യുന്ന സാഹചര്യം ഉണ്ടായിട്ടുണ്ട്. വിദ്യാർത്ഥികളുടെ ഇടയിൽ പോലും അത്തരത്തിലുള്ള പ്രവണതകൾ ഉണ്ടായി വരുന്നു. നമുക്കറിയാം. തീർച്ചയായിട്ടും അത് മുന്നിൽ കണ്ടുകൊണ്ട് തന്നെ നമുക്ക് എന്തൊക്കെ ഈ മേഖലകളിൽ ചെയ്യാൻ സാധിക്കുമെന്നത് നമ്മൾ ചർച്ച ചെയ്യേണ്ടതായിട്ടുണ്ട്. ഇന്നത്തെ രാവിലത്തെ സെഷൻ പ്രധാനമായിട്ടും ആൻ ഓവർവ്യൂ ഓഫ് ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ്സ് എന്നുള്ളതാണ്, IPR. അത് തീർച്ചയായിട്ടും നമ്മൾ മനസ്സിലാക്കേണ്ടതായിട്ടുണ്ട്. ഒരുപക്ഷെ നമ്മുടെയൊക്കെ പാഠപുസ്തകങ്ങളിൽ തന്നെ നമ്മുടെ കരിക്കുലത്തിന്റെ ഭാഗമായി തന്നെ IPR ഇന്ന് പഠന വിഷയമായിട്ടുണ്ട്. നമുക്ക് സ്വന്തമായി നമ്മൾ കണ്ടെത്തുന്ന വിഷയങ്ങൾ അത് നമുക്കറിയാം. നമ്മുടെ പേറ്റന്റ് റൈറ്റുകൾ മാത്രമല്ല, നമ്മുടെ പകർപ്പവകാശം പോലുള്ള മറ്റു കാര്യങ്ങളും എല്ലാം ഇതിന്റെ കീഴിൽ വരുന്നുണ്ട്. തീർച്ചയായിട്ടും ഈ ക്ലാസ് നിങ്ങൾക്ക് തീർച്ചയായിട്ടും പ്രയോജനപ്പെടുമെന്ന കാര്യത്തിൽ യാതൊരു സംശയവും വേണ്ട. ഇത്തരത്തിൽ മിനിസ്ട്രി ഓഫ് എഡ്യൂക്കേഷൻ നടത്തുന്ന ഈ ലെക്ചർ സീരീസിലെ ഇമ്പാക്ട് ലെക്ചർ സീരീസിലെ ഇന്നത്തെ ഈ നമ്മുടെ കോളേജിൽ നടക്കുന്ന ഈ പ്രോഗ്രാമിന് എല്ലാ ആശംസകളും നേരുന്നതോടൊപ്പം ഇതിൽ പങ്കെടുക്കുന്ന നിങ്ങൾക്ക് തീർച്ചയായിട്ടും ഇതിൽ നിന്നും വളരെയേറെ അറിവുകൾ ലഭിക്കട്ടെ, നിങ്ങളുടെ സംരംഭകത്തിലേക്കുള്ള നിങ്ങളുടെ നീക്കങ്ങൾക്ക് കൂടുതൽ ഉത്തേജനം നൽകട്ടെ എന്ന് ആശംസിച്ചുകൊണ്ടും നിങ്ങൾ ഏവരുടെയും അനുമതിയോടുകൂടി ഇന്നത്തെ ഈ പ്രോഗ്രാം ഉദ്ഘാടനം ചെയ്തതായി അറിയിച്ചുകൊണ്ട് നിർത്തുന്നു. നമസ്കാരം.
Thank you so much, sir. Let me invite our beloved teacher, Ms. Tinchu P. James, Assistant Professor of Department of Political Science, to introduce resource person of the morning session, Ms. Devika and Nair.
ഇന്നത്തെ ഈ സെമിനാറിന്റെ വിശിഷ്ടാതിഥി ശ്രീമതി ദേവിക ആർ നായർ, ബഹുമാനപ്പെട്ട വൈസ് പ്രിൻസിപ്പൽ, സ്നേഹം നിറഞ്ഞ അധ്യാപക സുഹൃത്തുക്കളെ, വിദ്യാർത്ഥി സുഹൃത്തുക്കളെ, നമ്മുടെ കോളേജിലെ ഇൻസ്റ്റിറ്റ്യൂഷൻസ് ഇന്നോവേഷൻ കൗൺസിൽ ഒരു ഇമ്പാക്ട് ലെക്ചർ സീരീസ് ഇവിടെ നടത്തിക്കൊണ്ടിരിക്കുകയാണ്. അതിന്റെ ആദ്യത്തെ സെഷനാണ് ഇപ്പോൾ ഇവിടെ നടക്കാനായിട്ട് പോകുന്നത്. നമുക്കറിയാം, വിദ്യാഭ്യാസ സ്ഥാപനങ്ങളിൽ വിദ്യാർത്ഥികളുടെ സംരംഭകത്വം പ്രോത്സാഹിപ്പിക്കാൻ, അതുവഴി സമ്പദ് വ്യവസ്ഥയ്ക്ക് തന്നെ സംഭാവനകൾ നൽകാനും സമ്പദ് വ്യവസ്ഥയെ കൂടുതലായി ഉയരത്തിലേക്ക് അല്ലെങ്കിൽ വളർച്ചയിലേക്ക് നയിക്കാനും ഒക്കെ വേണ്ടിയാണ് ഗവൺമെന്റ് ഇങ്ങനെ ഒരു സംരംഭകത്വം പ്രോത്സാഹിപ്പിക്കുന്നതിന് വേണ്ടിയിട്ടുള്ള വിവിധ സെല്ലുകളും പരിപാടികളും ഒക്കെ നമ്മുടെ കോളേജുകളിൽ ഇങ്ങനെ സംഘടിപ്പിച്ചുകൊണ്ടിരിക്കുന്നത്. 2019 മുതൽ നമ്മുടെ കോളേജിലും സജീവമായി ഇങ്ങനെ സംരംഭകത്വം പ്രോത്സാഹിപ്പിക്കുന്നതിന് വേണ്ടിയിട്ടുള്ള പ്രവർത്തനങ്ങൾ നടന്നു വരുന്നുണ്ട്. അതിന്റെ ഭാഗമായിട്ടാണ് ഇവിടെ ഇപ്പോൾ ഇങ്ങനെ ഒരു ഇമ്പാക്ട് ലെക്ചർ സീരീസ് സംഘടിപ്പിച്ചിരിക്കുന്നത്. തീർച്ചയായിട്ടും നമുക്കറിയാം, ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ്സ് അല്ലെങ്കിൽ ബൗദ്ധിക സ്വത്തവകാശം എന്ന് പറയുന്നത് ഇന്ന് ഒരുപാട് ചർച്ച ചെയ്യപ്പെടുന്ന ഒരു വിഷയമാണ്. From the time when WTO became an institution which replaced GATT, and the topics like TRIPS and TRIMS, trade-related intellectual property rights and trade-related investment measures, came as a hot topic of discussion. There were a lot of concerns like patents, copyrights, and the concerns of third world and all. Right now, we have an eminent personality, Srimati Devika Nair, who has a learning in all these fields, and she is talking to us on an overview of intellectual property rights. This is the first session of our Impact Lecture series. Right now, let me introduce our eminent personality. Srimati Devika Nair is working as an examiner of patents and designs in Intellectual Property Office, which is under the Ministry of Commerce and Industry. She has close to 6 years of experience in dealing with patent applications, formal and technical examination of patent applications, and patent search. She has also been serving as an examiner in the International Search Authority Division of Patent Office since the last 5 years. She obtained her BTech in Electrical and Electronics Engineering from Government Rajiv Gandhi Institute of Technology, Kottayam, which is in 2014. So, with pleasure, let me welcome you, ma'am, to handle the session. Over to you, ma'am.
Thank you, ma'am, for the warm introduction. I hope I'm audible.
Yes, you are audible.
Yeah. So, first of all, I'd like to express my sincere gratitude to St. Thomas College, Pala, Honorable Vice Principal Sir, and Dr. Sajil Martin, Sir, President of IIC, for inviting me as a resource person for this session conducted in association with IIC and AICT. So, as already mentioned, today in this session, I'll be mainly discussing about intellectual property rights and their protection in India. I'd like to welcome all the students and faculty members of St. Thomas College, Pala, and all other participants who have joined with us today for this session. And I hope you all will find this session informative. As Honorable Vice Principal Sir already mentioned, the importance of intellectual property rights is growing day by day. So certainly this is a topic which you all should be aware of. So without any delay, we'll start the session. So this is a brief overview of the topics that we'll be covering today. First of all, I try to provide a general overview about intellectual property rights. Then we'll be discussing about the different IPRs that can be enforced in India. And I'll also briefly go through some career opportunities that are available in the field of IPR. And at the end of the session, we'll have a short quiz just to test your understanding of the session. And at the end, we can have a Q&A session. So those of you who have any doubts related to IPR or related to the topics that I present in this seminar, you can feel free to ask your queries. First of all, what is intellectual property? So if you go with the basics, what is a property? A property is something that you own, right? So it can be in the form of tangible property, such as a piece of land or the house that you own, the car or scooter or any of the vehicles that you own. So all these are examples of tangible property. Tangible means anything that can be touched or felt, right? So there is another category of property called as intangible property. Intangible is something that cannot be touched. So this intangible property mainly comprises of intellectual property. Now, what is intellectual property? As the name itself suggests, intellectual property is anything that is born out of your intellect. Anything that you create using your mind is called as intellectual property. Now, it can be in the form of a poem or a story that you have written. It can also be in the form of a song that you have composed or a movie that you have created. So all these are examples of creative works. So on the other hand, you can also have an idea which you can develop it into a scientific invention. So that will also come under intellectual property. It can also be in the form of the design of a product, right? Or it can be in the form of a logo that you design in order to represent your brand. So all these are examples of intellectual property. These are the different types of intellectual property. Now, what are intellectual property rights? These are the legal rights that are provided to the creators of such original intellectual property. Now, depending upon the type of intellectual property, we have the following types of IPR that are protected in India. First, we have patents. Patents are the legal rights that are provided for scientific inventions. Designs. Designs are the legal rights that are provided for unique and new designs. Okay, design means the design of a product or the design of an article. So we'll see in detail each one of these IPRs in the coming slides. Then we have trademark. Trademark is the legal right that protects the brand name or brand logo. Copyright is basically a right that is given to the creators of any kind of creative work. It can be an artistic work, a literary work, or a cinematographic work, or even a music composition. Then we have semiconductor IC layout design or SICLD. So these are the legal rights that are provided for unique and new IC layout designs, integrated circuit layout designs. Then last but not the least, we have geographical indications. So you might not be very familiar with this term. I'll give certain examples such as Tirupati Laddu or Kanjipuram silk, or you can have Aramula Kannadi. So I'm sure all of you must have heard about Aramula Kannadi. So it is basically a unique kind of mirror that is manufactured by the artisans who are living in and around the place Aramula. So basically that product has certain unique features and a recognition that is closely linked with its location. So such products are given this GI tag or geographical indication tag. So before moving into the different types of IPR, we need to understand the importance of IPR in general. So once you have created something, why is it important for you to secure an intellectual property right for your creation? First of all, it offers protection for your creation. How? By excluding others from utilizing, commercializing, and earning from it. For example, if you have written a poem, okay, this is a very simple example. If you have written a poem and tomorrow somebody else copies your poem and publishes it in a magazine in their name, then how will you feel? You'll feel cheated, right? Because it was your creative work and it was copied by somebody else without your permission, obviously. So in order to avoid such circumstances, you can make use of intellectual property right. So if you if you register your poem in your name by obtaining a copyright for your poem, tomorrow if anybody else tries to copy your poem or tries to unauthorized use it in an unauthorized manner, then you can prevent them. Why? Because you have the legal right over your creation. So this is the importance of IPR. Now these are a few more points which further emphasize the significance of IPR. First and foremost, as I already mentioned, it provides a security for your intangible intellectual assets. Now, if you consider a tangible property such as a piece of land, once you buy a piece of land, you will get it registered in your name. So that will basically ensure your legal ownership over that piece of land. In a similar way, once you create something, once you create an intellectual creation, you need to make sure that you get it registered in your name. It will basically provide security for your creation. Then secondly, licensing revenue. So an IPR enables you to earn in many ways. One of the ways is through licensing revenue. I'll just try to explain it. Consider that you have invented a new product. Now you may not have the legal and business acumen to manufacture and market the product. Then what you can do is you can approach a company which is already established in that particular field, in that particular market, and you can license your product, you can license your invention to them. So what they will do on your behalf, they will manufacture the product and they will market it. So whatever earnings they get by selling it, a part of that they'll have to provide, they'll have to give you in the form of royalty. So and they also have to pay a licensing fee. So this is how you earn through licensing. So this was just a simple example. There are multiple other ways in which you can earn through IPR. Then thirdly, it fosters innovation in different fields. So that is quite obvious. Now the companies basically find patent as a primary way in which they can earn through innovation. Then it helps companies protect their investments in innovation. So in order to explain this, I'll consider a simple example. Now we know that pharmaceutical companies, they invest a lot of money in research. So how do they recover this money? They recover this money through patents. They obtain a patent for their drug, and in this way, it helps them protect whatever the investment they made in research and development. Okay. So if there were no patents, then tomorrow any other company could reverse engineer their product and they could start manufacturing the same product. So in this way, the company which originally manufactured the product will no longer have any incentive for innovation. Then it rewards individual creativity and innovation. So from an individual standpoint, if somebody obtains a patent, then certainly it is a matter of great pride for them. So now we'll move on to the first category of IPR, that is a patent. So what is a patent? A patent is an exclusive right that is granted by government to a person or organization to stop others from making, selling, distributing and importing an invention within the territory of the country in which it is granted. So patent is a territorial right. It means that it is valid only within the territory of the country in which it is granted. And secondly, it is an exclusive right. An exclusive right means you yourself only will have the right over the product. You can stop others from commercially exploiting your product. Now, patent rights are valid for a limited period of time. So, in India, the term of a patent is 20 years. This means that you will have exclusive rights over your invention for a period of 20 years from the date of filing of the application. Once the 20-year period is over, your invention, which was protected by patent, will become available in public domain, and then it can be freely used and commercialized by anyone. So that is the meaning of validity for a limited period. Now, in exchange for such exclusive privileges, you have to disclose your invention completely and clearly in a patent specification. And this specification should be such that anyone having average skill in the art can reproduce the invention from the specification alone. So the specification should be so clear that whoever is reading the specification should be able to completely understand it from the specification alone. They should not require any other additional inputs from the inventor. That is what is meant by this line. So from this you can observe that the patent is essentially like a contract between the government and the inventor, wherein the government tells you that okay, you will get some exclusive rights over your invention, but in return you have to make your invention public. You have to disclose all information that is related to your invention. So this in a way will drive further research. Okay, so whatever information that is related to the patent will be made public, and in this way all others who are working in that particular field, they will get a free access to that information. That information will come in public domain. So anybody who is interested in that field, this information will basically help them to carry forward their research. Now, the patent system in India is governed by the Patent Act 1970. This is the legal framework that governs patenting in India. Now, before going into the nuances of patent, we need to understand what an invention is. Okay, so wherever you see such sections mentioned in brackets, they correspond to the act that is being discussed. So here we are talking about patents, so certainly all the sections correspond to the Patents Act. Now, an invention is a product or process which satisfies three main criteria. So what are the three criteria? First is novelty. Novelty എന്ന് പറയുമ്പോൾ പുതുമ, അതായത് നിങ്ങളുടെ ഇൻവെൻഷനിലോ നിങ്ങളുടെ പ്രോഡക്റ്റിലോ അല്ലെങ്കിൽ പ്രോസസ്സിലോ എന്തെങ്കിലും ഒരു പുതുമ ഉണ്ടായിരിക്കണം. Okay, it should have a feature which is not yet disclosed anywhere in public. It should have something new. That is what is meant by novelty. Then the second main criteria is inventive step. Now you may be thinking, what is the difference between novelty and inventive step? The difference is that the feature should not only be new, but it should also have some technological advancement over the existing technology. അതായത് ഇപ്പോൾ ഒരു ചെറിയ മോഡിഫിക്കേഷൻ വരുത്തിയിട്ട് നമ്മൾ പറയാം ഓക്കെ ഈ ഒരു മോഡിഫിക്കേഷൻ ഇതുവരെയുള്ള പബ്ലിക് ഡൊമൈനിൽ നോൺ അല്ല, പുതിയൊരു മോഡിഫിക്കേഷൻ ആണ്, അപ്പൊ ഇതിന് പേറ്റന്റ് കിട്ടുമോ എന്ന് ചോദിച്ചാൽ അത് ഡിപ്പെൻഡ്സ് ഓൺ ദി ക്രൈറ്റീരിയ ഓഫ് ഇൻവെന്റീവ് സ്റ്റെപ്പ്. Then there needs to be an assessment whether that new feature that you have added, whether it is technically advanced or not. Okay, whether it is something which is non-obvious. Non-obvious means whether that it should be something which cannot be easily imagined by a person who is working in that field. Okay, it should be something which is out of the box. In simple terms, something which is out of the box or which cannot be easily thought of by a person who is working in the related field. The third criteria is quite straightforward: industrial applicability. It means that your product or process should have some practical utility or industrial utility, right? It should be something which is of use to the society. All these criteria of patentability, they are evaluated as on the earliest filing date. So the day when you file your patent application for the first time is called as the priority date. So why is it called as a priority date? Because you are essentially securing a priority for your invention. So in patents, everything depends on the day when you file your application for the first time, because that is the day when you disclose your invention to the government. Okay. So whenever you file, that is called the priority date, the first filing date, that is called the priority date. Now, even if your invention satisfies all the below mentioned, like all the aforementioned criteria, there are certain reasonable restrictions that are imposed on the kind of inventions that can be patented in India. And these are given in sections 3 and 4 of the Patents Act. So we'll quickly go through some of these points. First, you can see that anything that is frivolous or contrary to well-established natural laws. So this means that frivolous is something that is fake, right? I'll just give an example. Like if somebody claims to have invented a machine which produces an output without any input, so certainly we know that it is not possible, right? As per the laws of physics, energy can neither be created nor be destroyed. It can only be transformed from one form to another. So certainly there should be an input from which an output can be produced. So such things cannot be patented. Then secondly, we have anything that is contrary to public order or morality, or which causes serious prejudice to human, animal, plant life or environment. So if somebody comes up with a new gambling machine, then that cannot be patented because it is against public order. That mere discovery or formulation of an abstract theory. So discovery means that inventions, only inventions can be patented, not discovery. Discovery means you are discovering or you are finding out something that was already existing. You are not creating anything new. Then mere discovery of a new form of a known substance without any enhancement in efficacy. So example of this would be the ethers, esters, salts and other derivatives of already known compounds. They cannot be patented unless they result in an increase in efficacy. Mere rearrangement of known devices, each functioning independently of one another in a known way. So an example of this will be an umbrella that is fitted with a torch. So in this particular example, the umbrella is also functioning independently and the torch is functioning independently. They do not have any interdependence. So such things cannot be patented. Then farming methods cannot be patented. Then method of treatment of humans or animals. Plants and animals in whole or any part thereof cannot be patented. Mathematical or business method or computer program per se or algorithms cannot be patented. So in India, computer programs are protected under copyright. Computer programs as well as software. So they cannot be patented. Then a method of performing a mental act or method of playing a game. Literary, musical, dramatic, artistic works cannot be patented. Again, they are also protected under copyright, not under patents. Mere presentation of information, such as if you are claiming something which is displaying some information, then certainly that cannot be patented because it is not having any novelty. Topography of IC. Again, IC topography cannot be patented because it is protected under a separate IPR called as semiconductor IC layout design. Traditional knowledge cannot be patented because as from the name itself, it is something which is known traditionally, right? For example, the use of turmeric to treat infections or anything that is related to yoga, all these cannot be patented. Then inventions related to atomic energy also cannot be patented in India. So now in order to make things a little bit more interesting, we'll go through some examples of some of the famous inventions that we have. Famous in the sense, yeah, many of you might not be knowing that this is an invention. So I'm talking about the shoes that was used by Michael Jackson in one of his dance performances. So in this dance performance, means in this particular music video, he had a move which is called as anti-gravity lean, where he bends to almost 45 degrees. So in order to perform this particular dance move, he manufactured this special kind of shoe which had a slot in its heel that could engage with a nail protruding from the stage. So this basically helped him perform this 45-degree lean, and he went on to obtain a US patent for this shoe of his. So you can note down the US patent number also if you're interested. You can type it in Google and you can go through the patent specification. Now this is another famous example of an invention that you all must be familiar in your real life. So I'm sure that all of you might have seen this LED wicket system in the most of the cricket matches that are being held now. So this was invented by an Australian mechanical engineer and a former cricketer. So before this, it was difficult for the umpires to judge the precise moment when the bails fell off from the stump. So that was when this Australian mechanical engineer called Ron Teckerman, he came up with this idea of using an LED sensor and microcontroller in this wicket system in order to, which these LEDs would basically light up when the bails got dislodged from the stump, and this would happen within milliseconds. So it was kind of instant, right? So it was adopted by ICC. The mechanical engineer, he obtained a patent for this particular invention, and this was in due course of time, it was adopted by ICC in all its matches. I think in 2013, ICC started using this particular wicket system, and from then on, it has made umpiring a lot more easier. Here also you can see the Australian patent number. Now these are some famous Indian innovations. First you can see the affordable hepatitis vaccine Shanbag B, which was developed by Shanta Biotechnics. So before this, the hepatitis vaccine that was available, that was very costly, and it was not affordable to large segments of population in India. So that was when this particular Indian pharmaceutical company, they came up with this idea of using an indigenous yeast strain in order to develop this cheaper variant of hepatitis vaccine. And from then on, there was no looking back. They obtained a patent for it, and now it is. I think it was even introduced as a part of this universal immunization program in India, and it is exported to many underdeveloped and developing countries as well. Then another famous innovation from India is Jaipur foot. So you might have heard about this prosthetic leg. It is also a very affordable and cheap prosthetic leg that was manufactured in India, that was invented in India. Now this is a very inspiring example of a small kid who is just 6 years old, Vishalini. She even got the Pradhan Mantri Rashtriya Bal Puraskar this year. She is actually she is one of the youngest patent holders in India, and she had she got a patent for her invention, an automatic multifunctional life rescue flood house. So it was something. It was a sort of a temporary arrangement which could, in the form of a boat, which could modify itself in the form of a small house, and it had all the essentials which could help somebody survive floods. So she got a patent for this, and this is basically an inspiration for all of us that age or qualification, there is no bar on age or qualification as far as obtaining a patent or as far as innovation is considered. If you have an idea, then please try to develop it into an invention, and certainly you can go for patenting. So those were the few examples that we discussed. Now we move on to the filing aspects of a patent application. So now suppose you have an idea and you want to file a patent application for it, then what are the steps that you should follow? First of all, the filing procedure. There are two modes in which you can file. Physical filing, where you have to submit the hard copy by post in the appropriate patent office, and online filing, where you can use the comprehensive e-filing portal in order to file your application online. So in case of physical filing, you see the term the appropriate patent office. So what does it mean? So India has 4 patent offices in Delhi, Mumbai, Chennai and Kolkata, and each office is mapped to a particular jurisdiction. So if you belong to any of the southern states of India, or if you are doing your business in any of the southern states of India, then your appropriate office will be Chennai office. Okay, you have to submit the application in Chennai office. So this is a screenshot of the this is a screenshot of the e-filing portal. You can register here using your details, and then you can log in and file all the different forms that are required to be filed. You can submit your patent specification also. Now we'll see the different forms that are involved in this. So there are certain formalities that you should fulfill in order to file a patent application. So we'll just go through this, the most important forms. Okay. So first we have form 1. It includes all the details of the applicant as well as the inventor. So name of the applicant, name of the inventor, their addresses, all these things need to be furnished in form 1. So here you might be confused as to what is the difference between applicant and inventor, right? So mostly if you are not associated with any organization or a company, then if you are the inventor, you can be the applicant as well. However, if you are studying in a college, okay, for example, if you are for the students of St.Thomas College, or for the faculty members of St.Thomas College, then the applicant will be the college, and the inventor, you will be recognized as the inventor, because you are making use of the facilities in your college, right? So certainly the college will be recognized as the applicant, and you will be recognized as the inventor. Same is the case if you are working in a particular organization or a company. The company or the organization will be recognized as the applicant, and you will be identified as the inventors in form 1. Then we have form 2. Form 2 is the patent specification. So earlier itself I told that a patent is basically a kind of a contract between the government and the inventor, where the inventor or the applicant discloses his invention in the form of a patent specification. So this should have all the details related to your invention, such as title, background, description, drawings, abstract and claims. Now here the word claims comes. So what does this mean? So in order to understand the importance of claims, let's consider a simple example. Now we know that patent is an intellectual property, right? If you consider a tangible property such as a piece of land, the claims will be equivalent to the fencing or the boundary that you provide for your land. So why do you provide a fencing for your land? In order to avoid trespassing by others, and also in order to secure the boundaries of in order to secure the boundary of your property, right? In the same way, claims define the boundary of protection for your patent or for your invention. So whatever claims are written in the form of certain numbered features, and whatever points you mention in claims, you will get protection only for those features. If you have written something in the specification, but if you have not defined it in the claims, then you will not get protection for those features. So you have to be extremely careful while drafting the claims of a patent specification. So that is the importance of claims. Now again, we'll go back to the forms. Then we have some other forms also. Form 3. So earlier itself I mentioned that patent is a territorial right. It is valid within the territory of the country in which it is granted. So certainly you might want to obtain patent in other countries as well, so that you can market your product in those countries as well. So what you can do is you can file different applications in different countries. So here in India, you have to provide the details of all such foreign applications that you have filed for the same invention. So that needs to be done in form 3. Then next we have form 5. It is a simple declaration in a particular format that is given. Then Form 18 is very important. It is called the request for examination. And unless and until you file Form 18 or the request for examination, your application will not be taken up for examination. And it needs to be filed within 48 months from the priority date. So if you forget to file Form 18, then your application, your patent application will not be examined. So it is very important. So we'll quickly go through the fee details that are applicable. So the fee that needs to be paid depends upon the type of applicant. So there are mainly two categories of applicant. First, we have a individual, startup, small entity, or educational institution. So all these types of applicants, they are clubbed together into a single category. So if you fall in any of these categories, then the fee that needs to be paid is just rupees 5,600. So this includes the fee for Form 1 as well as the fee for Form 18. And if your complete specification is within 30 pages and claims is within 10, then you need not pay any fee for your specification. Otherwise, you need to pay an additional fee for each extra page and each extra claim. On the other hand, if the applicant is a company which is other than a startup or small entity, then the total fee that needs to be paid is rupees 28,000. So you can see that the fee that needs to be paid by an individual or a startup or an education institution is just 20% of the fee that needs to be paid by a multinational company. So this has been done by the government in order to encourage more and more individuals and startups and educational institutions to come up with innovation. So all these fees are applicable in case of online filing. In case you are going for offline filing, you need to pay a 10% additional fee. Now there is a provision of expedited examination. Now usually the patent application is taken up for examination in the order of the request date. So if you want the process to be expedited a little bit, then what you can do is you can opt for this expedited examination. For this, you have to file Form 18A and you have to pay some additional fee. However, there are like only certain categories of applicants can apply for expedited examination. So if the applicant is a startup or a small entity or a female applicant. So this was done by a recent amendment to the Act. So government has introduced this facility whereby female applicants can also opt for expedited examination. In case of multiple applicants also, if at least one applicant is a female, then they can opt for this facility. Then government departments or government establishments can also opt for expedited examination, and some other points are there which are not much relevant. Now we'll see that if you have an idea, then before applying for a patent, what all you need to do in order to ensure that your idea is patentable. So once you have an idea for an invention, the first thing that you should do is you should conduct a patent search. So a patent search will basically help you get an idea about the about the level of research that is going on in that particular field. Okay, you can also get an idea to documents which have already been published and which are related to your invention. So in this way, you can make further modification to your invention so that it satisfies the patentability criteria. Now, a patent search can be conducted in, there are many sources where you can conduct this patent search. Indian Patent Office itself has a database, online database where you can easily search, or these databases of foreign patent offices such as EPO, European Patent Office, or US Patent Office, or World Intellectual Property Organization. So WIPO is basically an arm of United Nations which makes certain guidelines, uniform guidelines which are to be followed by the different patent offices of the world. So they also have a database where you can perform free of cost search, or the most reliable and the most easy to use platform would be Google Patents. So just like Google Images or Google News, you have Google Patents also, where you can perform a free of cost search by just entering the different keywords that are related to your invention. You can retrieve documents, both patent as well as mainly patent literature that is related to your invention. Non-patent search. So not only in patent literature, you can search, you can perform a search in non-patent literature as well. So non-patent literature means any research paper or journals that are related to your invention. So this search can be done in Google Scholar or the search engines of famous research paper journals such as IIIC, Elsevier, etc. Or through simple web search. Sometimes a simple web search on Google would also yield, may also yield many results that are extremely relevant to your invention. So once this patent search is conducted, you will be able to assess the patentability of your invention. So it needs to satisfy all the three criteria. Plus, it needs to you need to ensure that your invention does not fall in any of the non-patentable sections of 3 and 4 that I discussed previously. So once all these criteria are met, you can safely go for the filing of a patent application. You can draft your application and you can file it. Now here we also have a facility whereby you can file a provisional specification. Now suppose you are working on something and you feel that it will take some time for the work to be completed. Then what you can do is you can opt for the filing of a provisional specification. The advantage of a provisional specification is that you just need to provide a brief overview of your invention. You need not file the claims. And once a provisional is filed, you get a time period of an entire year within which you can draft the complete specification. Okay, so within this 1 year period, you can easily complete the work on your invention and you can clearly draft the claims and you can go for filing of the complete specification. So the advantage of filing a provisional specification is that you secure an early priority date for your invention. So earlier itself I mentioned that the patentability is assessed as on the priority date. So suppose that you file a patent application today. Okay. So once we receive the application and once we receive a request for examination, we'll basically conduct a search at our end in order to find whether there is something, whether the already existing published documents, there is something which is related to your invention or not, or is there something which is very similar to your invention. So in order to assess that, we'll conduct a search on our end. So this search will be conducted for documents which have been published before your filing date or before your priority date. That is why securing an early priority date is extremely important. So sometimes the difference of a few days itself can prove detrimental, because you know that every day new and new innovation, this research is very fast growing. So every day a new research is happening and a new product or a new process is being created. So even the delay of a few days can prove detrimental for your patent. So that is why it is always beneficial to secure an early priority date by filing a provisional specification. Now we'll move on to the steps that are involved in the processing of a patent application in India. So once you file your application, at the end of 18 months, it will be published in the official patent journal. Okay. So this official patent journal is can be freely accessed by all on our website ipindia.gov.in. It is basically an online journal and it is released every Friday. So if you are interested, you can go to the website ipindia.gov.in. You can see this official journal of patents in order to get an idea about the type of applications that are being filed in India. So once this application is published, assuming that a request for examination is filed, your application will be taken up for examination depending upon the date of request. Okay, the order of the date of request, it would be taken up for examination. Then examiners, that is people like us, will examine your application. We'll assess the patentability of your application by conducting a search in our database, and then we'll draft a report. So this report will basically contain all the objections that are related to your patent application. It will contain a detailed assessment of the patentability of your invention. So this report will be put up to the controller, who will then issue the first examination report. So basically the first examination report is a summary of the objections that are related to your patent application. It will also contain documents, reference to documents that are related to your application, the closest documents that are related to your application. So once this FER is issued and is dispatched to the applicant will have a time period of 6 months to file a reply. So within the 6 months, the applicant needs to file a reply to the FER. So in reply, he needs to basically address the objections that were raised in the FER. Okay, and he can also make amendments to the claims and the specification to such an extent that the amendments fall within the scope of the original disclosure. So he cannot add anything new, like new in the sense something that was not previously disclosed in the specification. At this point of time, if he is adding some new feature which was not earlier disclosed, then it means that it is basically bypassing the priority date, right? Because the priority date is essentially the date when he first disclosed his invention to the government. So he has to make sure that whatever amendment he is making, that matter lies within the scope of the original disclosure that he did on the priority date. So once the reply is filed, the amendment will be examined by the examiner. Again, a report will be issued called subsequent examination report or a hearing notice. So depending upon the objections that are pending, again the applicant may have to attend a hearing. So nowadays the hearing is conducted through video conferencing as well. So again, depending upon the merits of the case, depending upon the patentability of the invention, the application may either proceed towards a grant or a refusal. So this is the timeline of a processing of a patent application in our office. Now these are some basic timelines that you as an applicant need to adhere to. Okay, so again, most of them we have discussed. You can just quickly go through. That provisional to complete, the timeline is 12 months. Complete should be filed within 12 months from the date of filing of provisional. Request for examination, it should be filed within 48 months. Reply to FER within 6 months. So these are the most important timelines. So this is a sample of the patent certificate that is issued to you once your patent is granted. So here you can see that the name of the patentee is mentioned, the title of the application is mentioned, the invention for which this patent was granted, that is also mentioned here. By default, the patent certificate does not mention the name of the inventors. However, if you need it, if you need the inventor name to be mentioned, you can file a form called Form 8. So with the help of that, you can get the name of the inventors also mentioned in the patent certificate. So that was all about patents. Now we'll move on to the next category of IPR called design. So what is a design? So earlier we discussed about patents. So patents basically cover the technical or the functional aspects of a product or a process. However, on the other hand, designs are basically related to the aesthetics or the appearance, external appearance of a finished article or a finished product. So you might be thinking that like what is the importance of a design, right? It is actually very important. Often, like if we take a simple example, if you go to buy a smartphone, so you see two phones which are identical in terms of their functionality and their specification, okay, which are exactly same with respect to their specification, but which are different only by way of their design. Like one of them looks more attractive as compared to the other, then certainly there are more chances that you would like to buy the phone which is more attractive or which looks better. Okay, considering that both the phones have the same specification or the same functionality. So certainly in this case, design has had a significant impact on your choice, right? So in this way, it is observed that designs play a very important role in affecting consumer choice. Now, another example to emphasize the importance of design. So once what happened is that a few Japanese researchers, two Japanese researchers, they carried out a research. They carried out a simple experiment. What they did was they designed two ATM machines which were exactly identical in terms of their functionality. Okay, they only differed in terms of their design. So one had a very attractive user interface, and the buttons were also placed very attractively and in a very organized manner, while the other ATM had the buttons placed in a very irregular manner. Okay, the user interface was also not that attractive. So they put both these machines to test in Japan. And what they found was, like, people, the Japanese public, they were more interested in using the second ATM. Like they found the second ATM, which was attractive, to be more easier to use. However, actually they both were exactly same in terms of their functionality. It was not the case that one was easier to use than the other. However, due to that attractive design and user interface, people preferred to use the second ATM more. So that clearly emphasize the importance of design. So we'll try to know more about the registration of design in India. So this is governed by the Designs Act 2000. Now, what all features would come under design? Shape, configuration, pattern, ornament, or composition of lines or colors that are applied to any article and which are judged solely by the eye. So these are the important points that you need to take care of. Any aesthetic feature that is applied to article will be covered under design. So the design needs to be original and new for it to be registered. The term of a design is 10 years. So this is, earlier we saw that in case of patent, the term was 20 years. However, in case of design, it is just 10 years. However, it can be extended up to 15 years. Now, these are the examples of articles that can be protected under design. So here you can see that fashion designs can be protected under design. The design of a sari or of any clothing material, the design of sofa, jewelry set designs, this cup and saucer set designs. Here you can see that different bottles are there which are shaped differently, which have different patterns over them. So all these can be protected under design. Now, showing your IP is protected. Now, once you obtain a registration for your design, how do you show that your design is registered? So, in order to do that, each such article is to be marked with registered or REGD or RD, and also with the registration number. So, certainly, once you get your design registered, you will be assigned a registration number. So, you have to mark this registration number on each such article. So this will basically prevent potential infringement and will also help in legal action. So anybody who is viewing your article will come to know that its design is protected. Its design is already registered. So certainly they would think twice before copying your design. So that is how it protects, it prevents infringement. Okay. Now, as far as filing of design application is concerned, it can be in case of, again, here also you have two modes, physical filing as well as electronic filing or online filing. In case of physical filing, the hard copy of your design application can be submitted at any of the four offices, Delhi, Mumbai, Chennai, Kolkata. However, the designs are processed only in the Kolkata office. Unlike the case of patents, in case of patents, it is processed at all four offices. However, in case of design, it is processed only at Kolkata office. So your record will be digitized and will be sent to the electronic processing module in Kolkata, where it will be examined. So that was all about design. Now we'll move on to next category of IP, that is trademark. So I'm pretty sure that you all would be familiar with the concept of a trademark. It is basically a mark that is capable of being represented graphically in the form of a word, name, logo, etc. So what is the basic function of a trademark? A trademark serves to identify and distinguish the source of goods or services of one trader from those of others. Now suppose you go to buy a shoe. Suppose you Nike shoe aanu kadayil medikkan povunu. Appo Nike branding adil undavu alle adinte logo adil undavu. അപ്പോൾ ആ ലോഗോ കാണുമ്പോൾ തന്നെ നിങ്ങൾക്ക് മനസ്സിലാവും ഓക്കെ ഇത് ഒരു നൈക്കിയുടെ പ്രോഡക്റ്റ് ആണ്. സോ യു വിൽ ഓട്ടോമാറ്റിക്കലി ബി അഷ്യൂർഡ് ഓഫ് ദി quality of that particular product, and you will also come to know about the source of that particular product. So that is the basic functionality of a trademark. So here you can see several examples of entities that are protected under trademark. So taglines. So this is the famous tagline of Pepsi, as you all might be knowing. So this can be protected under trademark. Then you can see Cadbury, logo of Cadbury can also be protected. It means it is also protected. Even color combination. So here you can see that there is a unique combination of golden and purple. So this color combination is registered as a trademark in many countries. Then you can see sound marks can also be registered. So that is an interesting fact which you might not be knowing. So an example of this would be the roaring sound of a lion that accompanies the animation of MGM Studios. അപ്പോൾ നമ്മൾ ചെറുപ്പത്തിൽ കാണുന്ന കാർട്ടൂൺസിന്റെ ഒക്കെ തുടക്കത്തിൽ ഈ ആനിമേഷൻ കണ്ടിട്ടുണ്ടാവും. അപ്പോൾ ആ ഒരു എന്താ പറയുന്ന ലയന്റെ ആ റോറിംഗ് സൗണ്ട് പോലും ട്രേഡ് മാർക്ക് ആയിട്ട് രജിസ്റ്റർ ചെയ്തിട്ടുണ്ട്. നോട്ട് ജസ്റ്റ് ദി ലോഗോ ബട്ട് ഓൾസോ ദാറ്റ് സൗണ്ട്. അതുപോലെ അഡിഡാസിന്റെ ലോഗോ ഇതെല്ലാം രജിസ്റ്റർഡ് ട്രേഡ് മാർക്സിന്റെ എക്സാമ്പിൾസ് ആണ്. Now, what all are the qualities of a good trademark? So there are basically two qualities of a good trademark. First is that it should be distinctive. Okay, distinctiveness means that it should be something unique and non-generic. For example, if you try to trademark a slogan such as "Go Green," then it might not be possible, right? Because it is very generic. Okay, it does not have anything unique. Now, this is another interesting example of how a trademark should not be. Like Minnal Muraliile ee scene ellaru orkunnundavu. Appo idile oru Tovino ഉപയോഗിക്കുന്ന ഒരു ടീഷർട്ടിൽ ഈ ഒരു പർട്ടിക്കുലർ ബ്രാൻഡിംഗ് ഉണ്ട്. അപ്പോൾ ഈ ലോഗോ കാണുമ്പോൾ തന്നെ നമുക്കറിയാം that it resembles an already existing trademark and it is in fact deceptively similar to an already existing mark. So certainly this cannot be trademark. This is just a duplicate or a counterfeit product. So it cannot be trademark. So while adopting a trademark or while coining a trademark, you should take care that it should not be deceptively similar to an existing mark. Now these are some points related to the protection of trademark. First is that trademark registration is optional. Okay, suppose you have been using a trademark for quite some time and you have not registered it. So there is nothing wrong in it. Okay. However, if you register your trademark, the advantage is that it has an evidentiary value in courts. So tomorrow, if somebody else tries to use your trademark in an unauthorized manner, or if somebody else tries to copy your mark or create a mark which is almost similar to your mark, then suddenly you might need to court. You might need to go to court. So in such a case, if you already have your trademark registered, then that registration will serve as the primary evidence in court. Then you need not prove to the court that you are the rightful owner of the trademark. However, if you do not have a registration, then first of all, you need to prove to the court that you are the rightful owner of that trademark. So this is the benefit that you get by registering your trademark. Then initially the trademark is registered for 10 years. However, it can be renewed indefinitely. So mostly we see that once a brand gets established, it tends to continue using the same trademark. It may make some minor modifications, but still it tends to continue to use the same trademark. So that is why this facility of indefinite renewal is given. Okay, so once a company or an individual gets the trademark registered, they can continue to renew it indefinitely at a time, 10 years at a time. In case of non-use of the trademark for a continuous period of 5 years, or in case of non-renewal, trademark rights are lost. Then, trademark system is governed by the Trademark Act. So this is the law that governs trademarks in India. Now, you all might have seen these indication at different instances along with different logos or brand names. So what does this mean? The indication TM means that your trademark is unregistered or that your trademark application is pending before the trademark office. However, once you obtain registration for your trademark, you can use this particular symbol. So if you see a symbol, if you see this particular symbol in front of logos or along with brand names, then it means that that particular trademark is registered. Okay. So we'll move on to the next category of IPR, that is copyright. Again, copyright is a very famous term. It's a very well-known term. Copyright is basically a legal right that is given to the creators of original, creative, artistic, dramatic, musical, cinematographic work. Okay, so a copyright basically helps the creator prevent unauthorized copying or reproduction of his work. Now, first thing is that the copyright is an automatic right. So once you create your work, the copyright comes into existence automatically. So here also you need not explicitly register your copyright. Just as in case of trademark, here in case of copyright also, even if you do not register a copyright, you still continue to have a right over your creation from the day you created the work. So that is why it is called an automatic right. However, same as in case of trademark, here also, if you have a registration, then it will have, then that registration will serve as a primary evidence in a court of law in case of any future dispute related to your work. Okay, that is the benefit of obtaining a registration. Now here you can see that the tenure of a copyright is lifetime of the author plus 60 years. അതായത് ഓഥർ ജീവിച്ചിരിക്കുന്ന കാലത്തോളം കോപ്പിറൈറ്റ് വാലിഡ് ആണ്, അതിനുശേഷം ഒരു 60 years കൂടി അത് വാലിഡ് ആണ്. അപ്പൊ ഈ ഒരു എൻറ്റയർ പീരീഡിന് ശേഷം മാത്രമേ ആ കോപ്പിറൈറ്റ് പബ്ലിക് ഡൊമൈനിൽ വരത്തുള്ളൂ. That work will come into, means that work can be freely used by anyone in public only after this entire term. Now, copyright basically allows the owner to choose the ways in which his or her works are made available to the public. For example, if somebody has written a novel, okay, then certainly that author will have the copyright over that novel. The author can then choose whether to publish that novel as in the form of a book, or whether to translate that into different languages, or whether to adapt that into a movie. Okay, adapt that into a movie screenplay. So all these things the creator or the copyright owner is free to choose. Now, the Copyright Act is the legal framework that governs copyrights in India. So, subject matter, what all comes under copyright? We have already discussed this. Copyright basically covers all these different types of works. So firstly, literary work means a novel, a book, a story, a short story, poems, all this would come under literary. So even earlier itself I told that computer programs in India or software, they are protected under copyright. So you can say that computer programs are also considered as literary work in India. Artistic works. So artistic works means painting or sculptures, all this would come under artistic works. Dramatic works, musical works, songs or compositions, sound recordings, then movies, cinematographic films, movies. Now, who all are the authors of the work? So depending upon the type of work, the copyright owner will be, copyright owner is clearly defined. So in case of a literary or dramatic work, the author will be the copyright owner. In case of a musical work, the composer will be recognized as the copyright owner and not the singer. Then in case of an artistic work, the artist. In case of photograph, the photographer. A cinematographic film or sound recording, the producer. And in case of a computer generated work, the person who causes the work to be created will be recognized as the copyright owner. So that was all about copyright. The next IPR that we'll be dealing is semiconductor IC layout design. So what is a semiconductor IC? Semiconductor IC is basically a product which has transistors and other circuitry elements inseparably formed on or inside a semiconductor or insulating material, and which is designed to perform an electronic function. Okay, so a semiconductor IC is nowadays it's a part and parcel of every electronic appliance or every appliance that you use, right? So the layout design is the layout of transistors and other elements, and it also includes the lead wires that are connecting such elements. So the layout design of such ICs can also be protected. There is a separate IPR category which protects the layout designs of ICs, and that is called as a semiconductor IC layout design. Okay, so under this particular IPR, new and unique IC layout designs can be registered. And this is located in Delhi. So out of the 4 IPR offices, Delhi office deals with this particular IPR. The tenure of protection offered is 10 years. So the rights which are given for this particular type of IPR will be valid for a term of 10 years. So the last category of IPR that we will be discussing today is geographical indication. Okay. So these are called as the invaluable treasures of incredible India, or Atulya Bharat ki Amulya Nidhi. So what is a GI? A GI is basically an an indication that identifies a product which has. So there are 2 main features here. First is it should have a specific geographical origin, and secondly, it should possess certain qualities or characteristics or a reputation that are due to that origin. So earlier itself, during the introduction phase itself, I gave you the example of Aramula Kannadi. So Aramula Kannadi nu parayna our product in certain specific qualities undu, allengi certain specific characteristics undu. പിന്നെ അത് കൂടാതെ ആ ക്യാരക്ടറിസ്റ്റിക്സ് എന്ന് പറയുന്നത് അതിന്റെ ലൊക്കേഷനുമായിട്ട് ക്ലോസ്ലി ലിങ്ക്ഡ് ആണ്. ഓക്കെ, ആ ഒരു പെർട്ടിക്കുലർ ലൊക്കേഷനിലെ ആണ് ആ ഒരു പ്രോഡക്റ്റിന്റെ ഒറിജിൻ, ഒരു സ്പെസിഫിക് ജോഗ്രഫിക്കൽ ഒറിജിൻ ഉണ്ട്. അപ്പൊ അതുകൊണ്ടാണ് ആ ഒരു പ്രോഡക്റ്റിന് ഈ ഒരു GI ടാഗ് കിട്ടിയത്. ഓക്കെ, അപ്പോ GI ടാഗിന്റെ 2 എന്താ പറയുക ഫീച്ചേഴ്സ് ആണ് ഈ പറഞ്ഞ 2 പോയിന്റ്സ്. Then who can apply? So in case of all other IPRs, we have seen that an individual can also apply, or an organization or an association or a company can also apply. However, in case of GI, an individual cannot apply. Only an association of producers of that particular product, or an organization which has been formed to look after the interests of the producers can apply for a GI tag, not an individual. So this is quite logical, right? Because നമ്മൾ പറഞ്ഞു GI tag വെച്ച് പ്രൊട്ടക്ട് ചെയ്യുന്ന പ്രോഡക്ട്സ് ഒരു പലതും ഒരു കമ്മ്യൂണിറ്റി, അതായത് ഒരു ലാർജ് സെഗ്മെന്റ് ഓഫ് പോപ്പുലേഷൻ ഇൻവോൾവ് ആയിരിക്കും in the manufacturing of that particular product. So certainly the rights, the exclusive rights over such a product cannot be given to an individual, right? Because it is something that affects a community or a large segment of the society as a whole. That is why an individual is forbidden from applying for a GI tag. So here you can see an example of a product from Kerala. This is the Pokali rice. So Pokali rice is a unique, highly saline tolerant variety of rice that is cultivated in the coastal belts of Ernakulam, Alappuzha and Thrissur. So this particular product was given GI tag. The certificate is given here for your reference. So you can see that this certificate has been awarded to Kerala Agricultural University and Pokali Land Development Agency, Ernakulam. Okay. So these are some other examples of certain products that have got GI tag in India. So from Kerala again you can find some other product called Alapi green cardamom, or Tirur Vettila, which is another famous product. Then from other states you can see Madurai Malli is there, Nagpur orange. Again, I'm sure that you all might have heard about Nagpur orange. So agricultural products can also get GI tag. Darjeeling tea. This was in fact the first product to get a GI tag in India. Makrana marble, Kanjipuram silk. Artistic works can also get GI tags, such as we have this Worli painting. Another famous GI tagged product from Kerala, Balaramapuram cotton sarees. So now we will summarize the whatever we have learned up till now. So here in this table, you can just go through this table. This basically shows the different IPRs that we have discussed up till now, the type of work that is protected by each IPR, and the duration. So here, this is just an example again to illustrate that all the products that you see around yourself, they might be having different or multiple IPRs associated with them. To take a simple example, if you consider the Apple MacBook, then the LED display of this particular system, it is a technical innovation, right? So it is protected under a patent. Then we have the design of this laptop, that is a registered design. Then the Apple sign or logo, a trademark. The user manual of this laptop, of this device, since it's a literary work, it will be protected under copyright. Then we have the semiconductor IC layout design is protected as a SICL design. So often due to lack of awareness, we fail to understand the importance of IPR or the presence of IPR all around us. So I hope that after this session, you will try to identify the different IPRs that you see around you, and certainly it will also help you it will also, I hope that this session will serve as a motivation for all of you to innovate and transform your intellectual assets into IPR. So to conclude, we have some points. We have some important points about the intellectual property rights. First is that first you should go for protection and then only publication. So in order to explain it in simple terms, if we consider the case of a patent, for example, suppose you have invented something, okay. So most often we see that researchers, they are always trying to publish their paper first, and then only they'll think about patenting. However, the right way to do this would be first registering for a patent, first applying for a patent, and then freely you can go for publication. So why is it advised to do like this? So once you go for publication, okay, suppose you publish your paper first. What happens is that it will be available in public domain, okay. So in that case, there is a chance that somebody who is working in the related field, may get inspired from your idea, and they would file a patent application, drawing some things from your paper. So in such a case, it will affect your chances of obtaining a patent for your invention. So in order to prevent such occurrences, the best way would be to first go for protection by filing a patent application, and then go for publication. Then rights are territorial in nature. We have already seen that the rights that are provided by IPR, by registering your IPR, they are valid only within the boundary of the country. Registration is done by sovereign authority. Then rights are valid for a limited period of time, and no automatic relief is there. So if you need to enforce your rights, you need to approach the court. So if somebody else is copying your product, or somebody else is infringing your IPR, then you need to file an infringement suit. You will not get automatic relief from the government. So this is simply a chart which shows the processing of different IPRs in different branch offices. So here you can see that this is basically our training center that is located in Nagpur. And patents, you can see that the patents are processed in all 4 offices. Designs are processed only in Kolkata office. And as far as trademarks are concerned, they are processed in all offices. In Ahmedabad, they are processed in Ahmedabad as well. GI or geographical indication is processed in Chennai only. Semiconductor IC layout is processed in Delhi, and copyrights are also filed and examined in Delhi only. Now we'll quickly go through some career opportunities that are available in this field. So as far as government sector is concerned, you can opt for any of these positions. Like you can apply for these positions, examiner of patents and designs. For this, the basic qualification is BTech for engineering field, and post-graduation for science field. Then law graduates can go for examiner of trademark, GI, or examiner of copyrights. Then so other opportunities are you also have the option to practice as a patent agent or trademark agent. So by practicing as an agent, you can basically help others in filing patent and trademark applications. Then you can go for fellowship in patent facilitation centers. Then nowadays in private sector, most of the companies, they have positions for patent attorney and patent analyst, so you can go in that side as well. So that was all with this session. So we'll have a short quiz. So I'll just ask some questions. So those of you who know the answers can either use the mic and can speak up. So I think, yeah, that would be the better option. Or you can type in the chat box, those who have joined online. Find the IPR. So you have different images shown here. First one, you have a painting. So till now we have seen different IPRs such as patents, designs, copyright, trademark, SICLD, GI. So you have to identify the IPR that is related to each one of these. First one, you have a painting. So can anybody tell me what is the IPR that is related or that is that can be used to protect a painting? Okay, I think I will give the answer. It is a painting is protected by a copyright. It is an artistic work, right? So it will be protected under copyright. Second one, you have a sculpture. Second one will also be protected under copyright. Why? Because it is an artistic work, right? So next we have third one, that is a logo, a Bisleri logo. So this will come okay, this will come under trademark. It's a logo, so it will be protected under trademark. Fourth one is a calling bottle. So you can see that it has a very unique design. So this will be protected as a design. Now, next is what protects the IP created by fashion designers. So you have certain options here: copyright, GI, patents, and designs. Yes, design is the correct answer. I can hear somebody saying design. It will be protected under design. What protects the advanced display for a bike developed by the inventors? Yes, patents is the correct answer. Since it's a technical innovation, scientific invention, it will be protected under patents. Now, which of these is a geographical indication? Yes, that is the correct answer. How long can a patent last? So, what is the term of a patent? Yes, 20 years is the correct answer. If you write an original story, what type of IP gives you the right to decide who can make and sell copies of your work? Copyright, yes. So copyright is the correct answer. Now, imagine a cricketer sets up his own company to sell his own range of clothes. What type of IP can he use to show that the clothes are made by his company? Okay, I can hear different answers. I think somebody told trademark. Trademark is the correct answer. So basically, the cricketer can design a logo. And this logo will basically help the consumer know that it was manufactured by this particular company. So trademark is the right answer. If a company develops a new technology that improves its main product, what type of IP can they use to stop others from copying their invention? Patent is the correct answer. So, since it is related to a technology, an improvement in technology, it will certainly come under patent. So that was all with this session. And I hope you all must have found this session information. If you have any queries related to IPR or anything that we discussed here, feel free to ask.
Now, I invite our respected teacher, Ms. Elsa George, Assistant Professor of Department of Physical Education, for proposing vote of thanks.
Good afternoon, all. Now it is time to express a few words of gratitude. At the outset, I thank our resource person, Ms. Devika R. Nair, Examiner of Patents and Designs, for the informative lecture and overview of intellectual property rights. The discussion provided valuable awareness and insight on the various aspects of IPR. Thank you, ma'am, for joining us in spite of your busy schedule. I would also like to express our sincere gratitude to our principal and vice principals for their support. Thank you, Joji Alexa, for the presidential address. A special thanks to the organizing committee, IIC St.Thomas College, Palai, for the excellent coordination. Thanks to our students for the active participation in the program. Now we move to the end of the session. Thank you.
Thank you, ma'am. Let's take a break now. Before that, I'd like to thank all the dignitaries and participants of the morning session. Afternoon session will be held at St. Joseph Hall at 1:45 p.m. on the topic How to Start an Industry by Mr. Lawrence Matthew. Let's all meet there. Thank you.